and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hello, Richard.
Hello, Lizzie. You're not looking very Christmassy today, unlike me.
I was going to say, what the listeners can't see is all your tinsel and Christmas trees and fairy lights in the background, which make for a very festive...
The fairy lights are at the front, actually.
Very nice indeed. So we're here to talk about a county court judgment from the 14th of November. The case is called Azam and Violet Developments. So do you want to tell us the background facts of this case?
Yeah, well, it all took place in Violet Street, 100 Violet Street in Tower Hamlets in East London. And in the background is Mr. Azam, who in 1997 he purchased a clothing manufacturing factory on this particular site. But years later, he saw that nearby, Berkeley Homes had got planning permission for a housing development in 2007 and seems to have thought to himself, why have I got this rundown factory when I could try and get planning permission for houses and make a fortune? And he originally tried to get planning permission between, he wanted 80 to 100 houses and some better commercial property, so it would sort of be mixed use premises. But he had problems getting a financing together and a joint venture together. But eventually he did get planning permission for 73 flats, I should say, not houses, but for 73 flats, 23 of which would have to be social housing. That was part of the planning obligations. And also commercial premises on the floor and basement. And what he did is he was going to grant a lease to Violet Developments. They had the expertise, or thought they had the expertise in sort of doing the development work. He'd give them a long lease, and then they could get the profits and from the residential development, and he would get the ground rents, from not from the social housing, but from the private sector housing. And it also get a lease back of the sublease, I should say, of the commercial element, so he'd still be running a business from there. And the lease was finally executed on December the 14th, 2015, a 999-year lease, as I said. And various stipulations, which were gone into in very great detail in the case, but they, amongst other things, had to complete the development as soon as reasonably practicable. And they basically didn't. Violet seemed to have gone into quite serious financial difficulties. It's Azam and Violet and Secure Trust Bank were also involved, were really the ones behind it. During the proceedings, Violet Developments went into insolvent administration, but Secure Trust Bank had loaned them a secure loan of £25.55 million, which was more than the sort of sale price of all these units would be. At least they had a secure loan. There were sort of about £6 million of unsecured loans, and it looks very much like those people are going to lose all their money. And also the directors of Violet Developments had guaranteed £3 million. It looks like they're going to become bankrupt. So all a bit of a disaster, but it was finally completed, the whole thing, on June the 25th, 2024. In the meantime, Mr. Azam had commenced forfeiture proceedings. If you bring in forfeiture proceedings for non-payment, other than for non-payment of rent, it comes within Section 146 of the Law of Property Act. You can actually peaceably re-enter, but under Section 146, you can effect forfeiture. You have to specify the breach, require remedy if remedy is possible, and require compensation if you wish it. But Section 146, subsection 2, allows the person who's had the premises forfeited to claim relief against forfeiture, basically be reinstated. And Section 146.2 goes on to say, I'll sort of paraphrase it a little bit, but the relief from forfeiture can be awarded on such terms as the court in the circumstances of each case thinks fit. So there's a large discretion. And that was the sort of background to it. They claimed relief from forfeiture. and Mr. Azam wants his compensation.
So what happened next?
Well, he wanted compensation for not just the stated purpose for, the reason for the forfeiture, the Section 146 notice and what had been stated. He wanted compensation for other things besides. I say in the Section 146 notice, there were various breaches specified. There was a bit of a debate about whether some of the breaches had been waived, so you couldn't affect it. But I'll leave that to another day. But he wanted compensation for other things as well. Various other things, most notably, the thing that was really an issue in the case was he wanted compensation for lost ground rents and various other things, also lost commercial rent because the property had been so late in completing. That was actually the major claim. But shall I tell you why he wanted the claim for lost ground rents, which was the sort of big issue?
Yes, go for it.
It's because the property could have reasonably been completed, or the reasonable expectation was that it would be completed by 2021 at the latest, if not a lot earlier. Whereas it wasn't completed, as I mentioned, practical completion was on June the 25th, 2024. And in the meantime, as you'll remember, on June the 30th, 2022, the Leasehold Reform Ground Rent Act had come into force. Other than for retirement homes when it was April 2023, they weren't retirement homes here. And the Leasehold Reform Ground Rent Act says that you can't claim the ground rent save in exceptional circumstances like a shared ownership, other than a permitted ground rent for new leases as of that date, the grant of new leases as of that date. And a permitted ground rent is a peppercorn. So because they weren't completed on time and sold on time, Azam doesn't have the benefit of anything but a peppercorn and meaningless rent. And so he wanted compensation for that. And well, that's what a lot of it was dependent. A lot of the 54 pages was all about sort of experts' evidence and things. When could it have been completed and what's the loss? And that's very much on its facts. But there were a couple of cases, or there were several cases mentioned going back many years. It's accepted that compensation under Section 1462 doesn't, there's a large discretion, if you like. And there was a case from 1912 on Section 146's predecessor, House of Lords case called Hyman and Rose, where the court said that you shouldn't place fetters on your discretion. And basically, you could still claim compensation, even if it was for losses that weren't sort of mentioned in the Section 146 notice. So in Hyman and Rose, they were able to claim a condition of relief from forfeiture was that the tenant provides security for restoration of alterations at the end of the lease. And there've been another, not recent, but more recent, there've been several cases over the years on this, actually, many cases going back many years. But there's another one called Southern Depot and British Railways Board in 1990, a Court of Appeal case, which the Section 146 notice, for instance, said that the reason for the breaches, the reason for the forfeiture, would be they had, in breach of the terms of the lease, they'd allowed the premises to be used for car parking and storage. But at a later stage, the landlords were British Railways Board. In a later stage, after forfeiture, then they found that Southern Depot, the tenants, had been committing other breaches. They've been using the premises as a marshalling yard for lorries and also storage, packing newspapers into these lorries, I presume for the purpose of their business and nothing else. But so that was the another example where you could claim that in compensation for that, even though it wasn't mentioned in the Section 146 notice. And also they dealt with the fact that, well, the argument from Violet Developments and Secure Trust Bank was that you can only claim compensation if it's based on normal contractual damages. And as nothing required Violet Developments to, sort of sell, even if they completed on time, there was nothing that required them to sell these various flats until after the Leasehold Reform Ground Rented Act had come into force. So there was no loss there. But the court decided that these things aren't based on normal contractual principles, which don't apply to the compensation. And it was important that Secure Lending Trust and Violet didn't get a benefit from being late. And so all those kind of things were discussed and decided. Shall I tell you the answer as to what the judge finally said?
Yes, please. Although I'm not allowed to say that anymore, so I'm not sure what I'm supposed to
No,
say
you can
instead.
say yes, please. That's your phrase. So they decided that compensation, there is a wide discretion. You shouldn't fetter your discretion, as it says in section 146, subsection 2. It's whatever the tribunal thinks fit in the circumstances. They got various levels of compensation amounting to around £1.4 million. And they got the compensation, including for the lost ground rents, which was £286,875 approximately. It's a bit of an established opinion, but and a lot of the decision is sort of dependent on the individual facts. A lot of these cases are. And it is quite a long case, but at the end, the judge, Her Honour Judge Evans Gordon, apologised for the length of the decision. She was asked to discuss huge numbers of things. But there you go. Only a county court case, but it's a reminder as much as anything. And quite unusual to have a contested relief from forfeiture case as well. And there it is.
Thank you very much, Richard.
My pleasure, as always, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.